Already in the communication in 2020, we have noticed that data protection authorities struggled sometimes to use the one-stop shop to apply the GDPR in the cross-border context because of the sometimes not clear, sometimes even, let me keep not clear national procedural rules. Because what the GDPR harmonizes are the powers. GDPR establishes the DPAs, harmonizes their powers, but the tools, the means with which they are applied on the national level, these are national administrative procedures. And there were different problems concerning conditions of what is a complaint and which information needs to be fulfilled so that a complaint is admitted on the national level. When and who is heard and to which extent admitted to participate in different roles in the administrative procedure. What is the position of the complainant when an authority follows up on the complaint, and so on and so on. And what is also the questions concerning confidentiality, protection of the confidentiality of the information, both submitted by the parties under investigation and the complainant to the authorities, and then shared between the authorities while cooperating on the basis of Article 60. And all these problems were visible at the level of Article 60. So when the lead authority who was investigating the case was tabling the decision under Article 60.3, and then afterwards, if there were relevant and reasoned objections which were not resolved and the dispute resolution on the basis of Article 65 was triggered, some of these problems were still repeated or were having consequences on the level of this dispute resolution because it was sometimes not clear who was heard and on what somebody should be heard again while the EDPB is taking the binding decision. So EDPB, in the light also what we have flagged in this communication from 2020, worked as Anu explained, on several guidelines concerning procedural aspects. There are guidelines on Article 60, on Article 65, what relevant and reasoned objections are about, and how they should be tabled. But finally, the wish list was, it's really already a tag word, wish list was produced, reached us in October, and already in October the Commission took the decision to act upon it. And we indeed embarked on this exercise of drafting the procedural regulation, and I'm using here very consciously the word regulation, because only this tool will allow us to harmonize sufficiently these elements in the procedure which are necessary so that the one-stop shop works smoother, one-stop shop and a dispute resolution. On which elements, also building on the basis of the wish list, did we focus? So let me distinguish broadly 4 elements. First, complaint. Here we looked very much into the issues the authority had while assessing and then again reassessing the questions of the admissibility of complaints. This goes back to the fact that in some member states a complainant needed to provide one information and in another member state a slightly different one. So when then the complaint was sent from the concerned authority which received the complaint to the lead authority which will be treating the complaint, sometimes the lead was reassessing the admissibility of the complaint, and there was a going back and forth. And here, so we address this element also in the light of obligations of the directly imposed by the regulation in Article 77, the right to submit a complaint, which should be, we are in the area of fundamental rights, very easy. Then we looked on second element, on the position of the complainant. And here one should, as we also do in the Commission, in the situations where we are the enforcer, which is not in the area of data protection, and on the basis of the Charter, on the basis of the fact or obligations of good administration, and the fact that nobody can receive the decision adversely affecting this person without being heard previously, we distinguished between two situations: when a complainant will be fully partially rejected and when the complainant will be followed up. And then we also will be providing for appropriate solution in the situation of full partial rejection of the complaint. It's really to enable the complaint to provide its views on the basis of the elements and the reasoning which an authority would like to adopt in the final decision rejecting the complaint. Yeah, so just being heard before an authority will address a decision negatively affecting somebody so the complainant to the complainant. If the situation when the complaint is followed up, it's the question to which extent the complainant should be included in the procedure, which is a procedure of an authority against parties under investigations, the controller processors. So we were addressing these two situations. Third element, the harmonization of the stages when parties under investigation, so controller processors, will be heard. So their due process rights, what I was talking about when I was speaking about the rejection of complaints. So also for them, harmonization of stage when and the shape, form in which they can make their views defend themselves against the possible future allegations which will be established in the decision. And the fourth element, it's in this project, concerns means or use deployment of the means already provided for in the GDPR, which can be used so that the authorities are reaching the consensus and are clearer about their divergences earlier in the process than only after the draft decision is tabled. Because this allows to factor in, to try to resolve them, first of all, before, and to factor them in already in the investigation, so that we do not have then problems should the scope of the investigation change on hearing, not hearing, including, not including in at the later stage.